Okay guys, Diddy, his lawyers, fresh legal documents. Let's get into this. Hey guys, it's Murad Morali. Hopefully you guys are all doing well today. Back at it again. It is daily and consistent content. Let's not waste any time. Diddy's lawyers, I don't know what's going on, but this guy really wants a speedy trial because, long story short, he is trying to push this to go to trial, guys, in April or May 2025. The magnitude of this case, the volume of evidence that they have, how much Homeland Security have that they've given to the prosecutors, how huge this case is, this would normally take 2 to 3 years before it goes to trial. But obviously Diddy is so silly that he wants this to go to trial ASAP because this man thinks that he can exonerate himself when there's so much evidence against you. Half of the cases that we've been talking to you about are from several separate civil lawsuits. The ones of racketeering, coercion and sex trafficking are criminal, so they're very different. Those are the ones of why he's in bars. So this is basically what he has stated. Dear Judge Subramanian, which is the new judge, obviously there's a letter to them because they have pointed out certain things that need to be addressed for tomorrow. October 10th, guys, tomorrow at 2 p.m. is the next hearing, so we'll be reporting ASAP, hopefully live, if not straight away, from what's going on. But the discovery phase is about to be The discovery in this case is voluminous, totaling several terabytes of electronic material and consists primarily of the following categories: cell phones, laptops, tablets, hard drives, cloud accounts, electronically stored information of third parties, cell phone, laptops, tablets and accounts, and business records from financial institutions, phone companies, hotels, airlines, and other businesses. Physical evidence seized in searches of the defendant's residence, law enforcement records, and search warrant returns, including cell phone location information. Wow. Beyond the information set forth herein, the government will be prepared to answer any questions from the court at the upcoming conference regarding the status and contents of discovery, including the various types of discovery, the status and anticipated timeline of extracting electronically stored information, and the anticipated time needed to produce the remaining discovery. The government has been in close coordination with the defense regarding the production of discovery in this case, and the government has prioritized the expedient production of the defendant's electronically stored information, which makes up a significant portion of the total discovery in the case. Since the defendant arrest on September 16th, the parties have engaged in extensive negotiations regarding the protective order, which the court signed on October the 4th and docketed on October the 7th. On September the 25th, the government requested hard drives from the defense for discovery, which it received on October the 1st. On October the 7th, the government made its first production of discovery, which included, amongst other things, a complete set of search warrants in the case, iCloud reports for 2 of the defendant accounts, and the defendant's phone seized on March 25th. Interesting. Which defense counsel specifically requested be produced in the first production. The following day, and as relayed to the defense, the government began copying over 40 devices and the other 5 iCloud reports belonging to the defendant, not 40 devices, which is expected to take several days due to the volume of the material. Damn, they have a lot of evidence. The government also informed the defense that in addition to those devices and cloud accounts, it is expected to make rolling productions within the next 30 days of hard drives that were seized from the defendant, the subpoena returns currently in the government's possession, and materials from the search executed at the defendant's residences and hotel room. To the extent that the defense position below suggests otherwise, the government wishes to clarify that if it has been endeavoring to extract devices seized from the defendant as quick as possible. Moreover, the government is producing the defendant's materials in the first instance without responsiveness or privileged reviews. Finally, the government informed the defense that it expected to produce the remainder of discovery, including electronic information seized from devices and cloud accounts belonging to other individuals, on a rolling basis by the end of the year. The electronically stored information from third parties must be reviewed. Defense position. Okay, so this is Diddy's position. The parties are in almost daily discussions concerning discovery. The defense intends to ask the court to require the government to immediately produce certain categories of information, namely copies of Diddy's electronic devices that were seized. Through our dialogue with the government, we understand that the government seized a significant amount of Mr. Combs' devices and data pursuant to search warrants that were executed on March 25th, 2024. The government has also seized additional belongings up to Diddy at the time of his arrest about 3 weeks ago. We also understand that the government is now beginning to review and copy these devices, including those that were seized. The timely production of these materials is critical to Diddy's ability to prepare his defense. And because these devices belong to Diddy, their production should not be delayed by the government's initial review. The government has indicated that it will be able to produce these devices in the next 30 days. With respect to other categories of Rule 16, we intend to ask the court to set a reasonable production deadline to allow for sufficient time to review the material in advance of a spring trial date. A spring trial date. Why is Diddy is pressuring his lawyers, guys, to rush this for a spring trial date? And I don't understand why. This man is going to be in bars then for New Year's, Christmas, Thanksgiving. He ain't getting out. Therefore, he probably wants to rush it because he thinks that he can be exonerated and be able to be free. When, beloved, that is not going to be taking place at all. As you can see from what I've read, to give you guys a quick review, it's basically stating that they have a large amount of evidence, over 40 devices seized, so much that they are only now beginning to go through. And his defense position is basically saying, we're going to have to go through this. We want you guys to go through it ASAP. We want to know what you guys have gotten so that we can prepare a defense, because we want that speedy trial. We want this to be for April, basically from what I've read. There's more documents. Defense position. P. Diddy continues to assert his right to a speedy trial, there we go, and intends to request a trial date for April or May 2025. Diddy also seeks deadlines for the filings of pre-trial motions with permission to raise certain pre-trial motions. For example, at some point today, Diddy intends to file a motion for a hearing and other remedies related to unauthorized and prejudicial leaks of grand jury information. The government's position. The government will be available for trial on a date set by the court, although it remains within the court's discretion to set a trial date for whenever they want. Okay, so they let everybody know that basically that's, it's up to the court for when they want to do it. But obviously, that, guys, it's pretty quick for a case of this magnitude. It is insanely quick that they want to rush this to April, May 2025. To me, that is insane as to why they want to take it that level. Why don't they want to wait a couple of years? Because Diddy doesn't want to be behind bars a couple of years. He knows that Diddy is a very difficult client to have. The PR hated him. His team left him. Remember, a month ago, they all quit. He's been a hard person to work with. So he is pressuring his lawyers 24/7, which is why he's using all of his money to hire multiple lawyers to discuss this whole scenario on their neck, ringing them 24/7 to be like, bro, get me out of here. I want that speedy trial. Let's do it. For May, April is insane. Again, it's up to the court's discretion. Just like the court denied bond twice and appeal pending, they might even deny his request for a speedy trial. I doubt it, but you never really know. They might do that. The government's position and the defense position is what I've read to you guys from the fresh legal documents that came out today. It really goes to show you not only how dumb Diddy and his lawyers are for the fact that he's rushing for this, but that the amount of volume of evidence, many devices, electronically, everything, iCloud has all been seized, and they're going through everything slowly from back then, and even from things that they had taken from when he was even arrested. Do you even know what this means? It's going to be an absolute shit show. If we're going to do it for April and May, let's go. We're all going to be here discussing and talking about it, because I'd rather it be soon for us to discuss it than it to be dragged on for a couple of years. But April is basically, guys, in the next 5 months. I'm shocked, shell-shocked. But Diddy is rushing this because he wants to get out of jail. That's honestly why he's doing this. He's panicking. It don't make no sense. Oh, Lord have mercy. This is going to be a shit show. I didn't expect these documents to come out today, guys. I'm very confused. But this is basically what's going to be discussed tomorrow. A lot of the discovery phase as well, and etc. So tomorrow, 10th of October, 2 p.m, we're going to be there. Subscribe, comment down below, give this video a thumbs up. I wanted to give this out to you guys. I wanted to give you guys a quick, sum of everything, but also read out the actual legal documents to you guys, because I feel like it's good to appreciate the legal terminology when discussing this. I know it confuses you guys. It confuses me as well. Most of us are not professional lawyers, so it will confuse us, but I think it's important to read out the legal documents word for word, verbatim, because that is needed. Subscribe, and I'll catch you guys soon for another video.